Okay, everyone, we're going to get started. Welcome. My name, for those of you who don't know, is Amanda Carling. I am the manager of Indigenous Initiatives here at the Faculty of Law. I am also the chair of the board at Aboriginal Legal Services, so I might know some people from in that capacity. And I co-teach a class here on wrongful convictions at the law school. So I used to work with an organization called Innocence Canada. But I'm really happy to be here now in the role that I am currently in, because I have the great honor and pleasure of getting to bring in, along with my colleagues, notably Professor Carrie Wilkins today, but I get to bring in excellent speakers like Miss Dr. Heidi, who I'm going to introduce shortly. Particularly, thank you for coming in such wild weather. We had a lot of people registered, and I thought, well, I'm not going to bother getting a bigger room for us because probably a whole bunch of people won't come out on a stormy afternoon on a Friday in January. But I'm so pleased that we filled every seat and then some, so that's wonderful. And particularly to see so many community members and folks from other faculties here, I'm really grateful for that, so merci. Some people criticize land acknowledgements as a colonial practice because, of course, ownership of land is not an Indigenous concept generally. And of course, I respect that criticism, and everyone is entitled to, you know, fly their own flag and do their own thing. But I'm Métis, my ancestors were the Red River Métis, and I am a guest here on this part of Turtle Island. So for me, the land acknowledgement and acknowledging the people who've been taking care of this land for a very, very long time is important. So I'd like to start by doing that. This land on which University of Toronto operates has been the site of human activity for at least 15,000 years, probably much, much longer. And even before that, for millions and millions of years, our plant ancestors and animal ancestors, the rocks and the water and every single thing that we as human beings need to survive on this land was here. We are a blip on the radar, really, in terms of how long we've been here, and all of those things are going to be here long after we are gone. So we should try to take care of them the best that we can. There have been many different groups of people, including the Huron-Wendat, the Petun First Nation, the Seneca, and the Mississaugas of the Credit River that have taken care of this land. This land is the subject of the Dish with One Spoon Wampum Belt Covenant, which is an agreement between the Iroquois Confederacy and the Confederacy of Ojibwe and allied nations to peaceably share and care for the land around the Great Lakes. And I recently had a conversation with some of the members of the Indigenous Law Students Association, and I think we are going to do some work as a group to figure out what our responsibilities under that covenant are as guests here on that territory. So I'm looking forward to that. And now I am going to introduce our guest speaker, Dr. Heidi Kiiwetinepinesiik. No, she's going to pronounce that. My apologies. Perfect. Thanks, Carrie. Carrie's not mic'd today, though. We'll have to edit his voice over mine. Is Turtle Mountain Ojibwe and an associate professor of political science at the University of Victoria. She's the director of the Graduate Certificate in Indigenous Nationhood and the associate director of the Center for Indigenous Research and Community-Led Engagement, which has the acronym of CIRCLE. That's great.
We came up with the acronym first.
Yeah, work backwards. She has a Ph.D. in American Studies from the University of Minnesota. Her research interests include Indigenous law and treaty practices, Aboriginal and treaty rights, and Indigenous politics in the US and Canada. She's the co-editor of Centering Anishinaabeg Studies, Understanding the World Through Stories, with two co-authors, and is the co-author of American Indian Politics and the American Political System with Dr. David E. Wilkins. Her research background includes collaborative work with Indigenous communities in the United States and Canada. She was awarded a SSHRC Insight Development Grant for her project titled Sakimay First Nation Governance, which aims to advance the development and resurgence of Anishinaabe political structures and institutions that are informed and shaped by Anishinaabe philosophies, values, and teachings. She's published in journals and articles in journals such as Theory and Event, American Indian Quarterly, American Indian Culture and Research Journal, and Michigan State University Law Review. I know that you're probably already sick of hearing me speak, but certainly this is just a small snapshot of all of the amazing things that she has done in the short amount of time that she's been here with us. In the world, I mean, like not since she got to Toronto. I had the pleasure. I had the pleasure of meeting Heidi first at Cape Croker, where we were generously invited by Professor John Burrows and his community to learn Anishinaabe law and context. It's an incredible opportunity, so for the students who are here in the room who haven't had a chance to check it out, I hope that you'll come with us next year if we receive the invitation again. And I had the pleasure of hearing Heidi speak yesterday, so I can say without reservation that she is a wonderful teacher and a really incredible person, and I feel really lucky that I get to hear her speak 2 days in a row. So with that, please help me welcome Heidi.
Well, thank you for that generous introduction. I was like, oh, did I send that long bio? That's unfortunate for you. But I really appreciate the warm welcome I've been given. I too want to acknowledge the territory I'm here, which has long sustained the Anishinaabe and Haudenosaunee, the Huron-Wendat, as you've acknowledged as well. And I'm really grateful for the numerous teachings, legal traditions, and political traditions that the Anishinaabe, in particular, have been able to generate through our rich and deep engagement with territory. So thank you for that acknowledgement. I also want to express my thanks and gratitude to Carrie Wilkins and Amanda Carling for the generous invitation to be here and for all their work in organizing this event. And of course, want to thank all of you for being here and putting up with the talk you're about to hear. And I'm really looking forward to hearing your thoughts. I originally, I think I had mentioned in the emails when they were like, what's your title? And I was like, uh-oh, now I have to decide what I'm going to talk about. And I was originally really looking to get into a pretty detailed discussion around the ways in which the canons of treaty interpretation or the canons of construction operate and how the courts have taken up Aboriginal and treaty rights in both the United States and Canada. I'm going to cover that just briefly. I'm not going to cover it at all. And instead have decided to kind of present a two-part talk that is a bit disconnected, but are the kinds of ideas right now that are driving how I'm thinking about the ways in which the courts have taken up Aboriginal and treaty rights. And I say that as somebody who was an undergrad when it was my first year in college when the Mille Lacs Band of Ojibwe in the state of Minnesota had taken their treaty rights case all the way to the Supreme Court and were successful in securing affirmation of their treaty rights. And the court relied heavily on the canons of construction. And so I very much was shaped by the idea that, and I will say that throughout that process, many of the Anishinaabe leaders who were working around the case were drawing heavily both on a number of amazing attorneys and expert witnesses and scholars, but more importantly, had really deeply turned to Indigenous legal traditions to drive the case. They had sent runners from the Great Lakes all the way to DC. They had engaged in extensive ceremonies to honor those who had died during the Sandy Lake removal. And so I kind of came into my kind of intellectual awareness of treaty rights in a place in which treaty rights had long been contested, had led to really violent protests in Wisconsin between sports fishermen and Anishinaabe who were spearfishing. And so I had a lot of hope when I was very young that the courts, if they would just rely on our interpretation of treaties, could really help us find a new way forward for coexisting. I'm a little less hopeful. But instead I've really come to see what are some of the limits of the canons of interpretation. And so the talk today is going to talk about how we think about land and how we think about knowledge, and how these two ways of kind of a disjunctured view of the two has really shaped what happens in the courts. So bear with me. All right. So there's a rich body of scholarship that calls for us to seriously consider how narratives, whether encoded in law or circulated through dominant society, and embedded in the national conscious, shape and inform how we understand ourselves and relate to others. So justice creation stories provide the Anishinaabe with a sense of belonging and outline our own relationships to our place, our relatives, and our nation. US and Canadian law and the national narratives that inform law and policy function as creation stories of the settler state. Patricia Tuitt notes, quote, "No sovereign entity exists without an accompanying set of narratives surrounding its emergence. It is through stories of settlement, conquest, exploration, and discovery that distinctive nations, peoples, and communities are constructed. Although such narratives are embedded in a variety of cultural forms, few of these are equal in weight to the narration of the processes in which an entity acquires legal shape and status." So law and the national narratives they contain serve as a window for ascertaining how the state came into creation, how each polity and its peoples imagined who they were, and legalized who they wanted to become. So as Lumbee legal scholar Robert Williams reminds us, these creation stories of the state, which often discount or utterly deny Indigenous narratives and are contingent on the erasure or absorption of Indigenous peoples into the state, have rendered law a loaded weapon. He contends that the seminal 19th century federal Indian law decisions remain ready for the hand of current justices who continue to employ these narratives as a means to deny Native peoples their political rights. Like the stories that gave it meaning, law, though, is neither fixed nor static. It is always transforming. So law, like the trickster, can have an altering impact on those it interacts with. As Greg Saris reminds us, stories can work to oppress or to liberate, to confuse or to enlighten. So law, as story in the US and Canada, has frequently worked to oppress Indigenous peoples and transform Indigenous narratives by subjugating these stories within the nation state, sometimes to the point of defining Indigenous rights out of existence. And this can be seen in the litany of Supreme Court decisions that ignore or reconfigure the history of treaty making in order to provide a legal justification for the creation of the state. Felix Cohen, who's the compiler of the 1941 Handbook of Federal Indian Law, viewed law as a social process and argued for a broader understanding of the creation and impact of law. Subsequently, he cautioned against understanding law solely based on the language of the courts, stating, "Although judges and lawyers need not be legal scientists, it is of some practical importance that they should recognize that the traditional language of argument and opinion neither explains nor justifies court decisions. When the vivid fictions and metaphors of traditional jurisprudence are thought of as reasons for decision, rather than poetical or mnemonic devices for formulating decisions reached on other grounds, then the author, as well as the reader of the opinion or argument, is apt to forget the social forces which mold the law and the social ideals by which the law is to be judged." Lakota scholar and activist Fine Deloria echoed Cohen's view in his critique of federal Indian law. It's so funny to give this talk to a bunch of law professors and students. He stated, quote, "Federal Indian law itself is a mythical creature because of it is composed of badly written, vaguely phrased, and ill-considered federal statutes, hundreds of self-serving solicitors' opinions and regulations, and state, federal, and Supreme Court decisions which bear little relationship to rational thought or contain a fictional view of American history that would shame some of our country's best novelists." He's funny. Law, though comprised of stories, differs from other literatures in an important way. So Kieran Dolan notes as much, stating, quote, "One irreducible difference between law and literature has often been reasserted, that legal interpretation cannot be assimilated to literary interpretation because the production and reception of texts within the law takes place within a context of the systemic application of state-sanctioned force. So narratives of discovery and conquest overshadow narratives of diplomacy, of the commitments made between nations. These destructive stories contain unlimited abilities for the nation-state to imagine and create itself anew. These creation stories allow the state, whenever it's expedient, to disregard earlier recognitions of Native sovereignty and political authority in favor of narratives of unlimited state sovereignty and absolute power vis-a-vis Native peoples. We see this, for example, in the United States in a number of ways. Like the trickster, stories can distract just as much as they can enlighten. The federal courts have been particularly successful in distracting us from our own stories by instead putting on a magic show full of fancy tricks that distract the audience by posing endless riddles so they'll be unable to see the sleight of hand that enables the justices to pull a quarter out from behind one ear. Like magic, the courts have used narratives to enable the state to slip between the real and the imagined to legitimate their claims by saying they are so. As one scholar puts it, quote, "Law is one of the many narrative forms that generated material truth out of discursive fiction." These stories of the state disorientate and misguide the listener as they traverse the legal landscape. The state has found itself caught in its own riddle, lost in a maze that purports to administer justice and act with morality, while imagining its sovereign authority is contingent on the suppression of Indigenous sovereignty. So Chief Justice John Marshall first posed the national riddle in 1823 when he utilized his legal imagination to reduce Indigenous land title to, quote, "a mere right of occupancy." In 1931, he again performed the trick of transforming Native nations from self-governing and independent nations to, quote, "domestic dependent nations." In both cases, the Chief Justice carried out unnecessary tricks that sought to distract from the larger questions of federation that the court had to contend with. Like any story, though, once it was told, there was really no way to recall it. As Leslie Marmon Silko reminds us in her novel Ceremony, recounting a contest among witches that escalates out of control and threatens destruction and despair for all, stories cannot be undone. So in her novel, they plead, "Take it back, call that story back." But the witch just shook its head. "It's already turned loose. It's already coming. It can't be called back." So Marshall, like the witches, sought in a later ruling to call back his creation of discovery and conquest that had subjugated Indigenous rights and lands within the supreme authority of the state. So in his 1832 decision in Worcester v. Georgia, he denied that discovery stripped Native peoples of their land title and instead sought to recognize Indigenous sovereignty and trust responsibilities that were outlined in treaty relations. He recognized in this case that the Cherokees' national character had not been diminished by having placed themselves under the protection of the United States. Rather, he said that, quote, "the very fact of repeated treaties with them recognizes it, and the settled doctrine of the law of nations is that a weaker power does not surrender its independence, its right to self-government by associating with a stronger and taking its protection." But these competing and overlapping opinions, collectively referred to as the Marshall Trilogy, have swirled around a legal universe, allowing the courts to gaze in any direction necessary to support their particular desires. So subsequent court decisions have been able to utilize the Marshall Trilogy to narrate countless stories that would, though sometimes upholding it, frequently legitimate the denial or erasure of tribal sovereignty. So while Johnson v. McIntosh, the title case in 1823, allowed for the territorial subordination of Native peoples through narratives of discovery, other creation stories of the state came to legitimate the jurisdictional absorption of Native peoples. So in U.S. v. Kagama in 1886, the courts asserted that Native nations, quote, "are communities dependent on the United States." Congress, therefore, had the plenary authority to pass legislation that would position Native peoples as subjects of the state because, quote, "the power of the general government over these remnants of a race once powerful, now weak and diminished in numbers, is necessary to their protection as well as to the safety of those among whom they dwell." So in order to lawfully abrogate treaties, the courts reconfigured protection as dependency and declared that Congress had authority, quote, "in respect to the care and protection of the Indians to dispose of tribal lands." Indeed, when states' rights had been sufficiently subsumed under federal power, which is what much of the Marshall Trilogy dealt with, the courts would sometimes dismiss their earlier, more historically grounded stories, such as Worcester, that had expressly precluded states from exercising their laws over Indigenous peoples, to instead allow for the rise of states' rights in dealing with Native nations. Protection became a national narrative the courts could utilize to erode tribal sovereignty. So, for example, the courts denied tribal jurisdiction over criminal jurisdiction over non-Indians in a case known as Oliphant v. Suquamish in 1978, because the courts argued that would have been, quote, inconsistent with their status as dependent nations. Rehnquist declared, quote, Indian tribes do retain elements of quasi-sovereign authority after ceding their lands to the US and announcing their dependence on the federal government. But the tribes' retained powers are not such that they are limited only by specific restrictions in treaties or congressional enactments. As the Court of Appeals recognized, he goes on to say, Indian tribes are prohibited from exercising both those powers of autonomous states that have been expressly terminated by Congress and those powers inconsistent with their status. The courts then have frequently reconfigured their trust responsibilities to tribes, conflating protection with dependency, and dependency then with limited or quasi-sovereignty. In the same way that Anishinaabe stories about Nanabuju, the trickster, often demonstrate the impact our actions have on creation, detailing how the land came to take its current shape, or outlining particular encounters that explain the animal features that resulted. Supreme Court justices' engagement and interaction with legal doctrines such as the trust doctrine in general and notions of protection in particular continue to reshape the legal landscape that Native nations must contend with. The courts have erected theoretical mountains that often prove difficult to pass and carved great divides between the legal world espoused in the early Marshall Trilogy, at least in Worcester, to those that have been more recently outlined in a number of cases, such as US v. Hickorea. So yet the legal landscape that was breathed to life in Worcester was no less dangerous or full of obstacles as the legal landscape we find ourselves contained within today. While Worcester recognized that a nation's sovereignty was in no way diminished or limited by bringing itself under the protection of another, it was still a world that had to contend with narratives that were incapable of reconciling Indigenous nations as separate sovereigns, connected through alliance and treaty while having retained political autonomy and self-determination. Previous stories of discovery and conquest circulated in dominant discourse and given legal force in Johnson were contingent on the subjugation of Indigenous peoples and their lands. These stories were alive and could not be called back. We also see this in Canada in a number of important ways, far more extensively than I actually cover here, because this is where I kind of couldn't get it together. But we can talk about a number of those other cases as well that come up that I won't speak to directly. So Indigenous nations in the United States have perhaps fared better in federal Indian law because of the early 19th century Cherokee cases that recognize an inherent Indigenous sovereignty, even if only to have that sovereignty diminished, stripped, or denied through doctrines like plenary power or implicit divestiture. Canada has perhaps been more muted in their articulation of Indigenous nations' political status. The Supreme Court has spoke to the political status of the Huron Nation in R.V. Siwi, detailing the unique relationship of Indigenous nations to European powers when they entered into treaties. So Justice Lemire wrote, quote, I consider that we can conclude from the historical documents that both Great Britain and France felt that the Indian nations had sufficient independence and played a large enough role in North America for it to be good policy to maintain relations with them, very close to those maintained between sovereign nations. So in detailing the treaties of peace and friendship, Justice Lemire finds clear indication, quote, that the Indian nations were regarded in their relations with the European nations which occupied North America as independent nations. In Conley and Woolrich, Justice Monk of the Quebec Superior Court held that, quote, the Indian political and territorial rights, laws, and usages remained in full force, finding that Indigenous nations were autonomous, quote, living within the protection of the Crown, but retaining their territorial rights, political organizations, and common laws. Justice King in Logan and Stiers instead, though, renders Indigenous nations as subjects of the Crown, stating, when looking to the Simcoe deed and the Holdeman deed, that in each of these deeds, this is him now, in each of these deeds it's made clear that those of the Six Nations Indians settling on the lands therein described do so under the protection of the Crown. In my opinion, those of the Six Nations Indians so settling on such lands, together with their posterity, by accepting the protection of the Crown, then owed allegiance to the Crown and thus became subjects of the Crown. Thus, the said Six Nations Indians, from having been the faithful allies of the Crown, became instead loyal subjects of the Crown. So the political status of Indigenous nations has not received broader attention in contemporary Canadian jurisprudence. Instead, Burroughs and Rotman contends that, quote, the current case law has defined Aboriginal powers of governance in a narrower manner than historic practices may warrant, noting, quote, this reduction in Aboriginal rights to governance simultaneously vests ever-widening powers of governance in non-Aboriginal institutions. The courts closely and carefully scrutinize Aboriginal expressions of governance while allowing broad assertions of Crown sovereignty to go unchallenged. Indeed, Section 35 jurisprudence has largely been framed within the aim of reconciling, quote, Aboriginal occupancy with this given Crown sovereignty. As such, Crown sovereignty is taken as a given. Even more concerning is the court's conflation, then, of Crown sovereignty with territorial authority. And in this moment, I would just gesture to Shiri Pasternik's book, who's here, on grounded authority, that takes up lots of these questions around sovereignty and how we can see the ways in which sovereignty is, in many ways, quite imagined when we turn our attention to questions of jurisdiction. And so Aboriginal title in Canada then draws on the U.S. Court's construction of Indian title, rendering Indigenous nations rich relationships with their territories to a mere right of occupancy or a usufructuary right. And importantly, both countries recognize that Aboriginal title cannot be ignored or denied, and that both turn to their treaties with Indigenous nations in these moments as assertions of the extinguishment of title, much to the behest, of course, of Indigenous nations that contest this framing of their treaty commitments to shared territory, with newcomers. So the court's reliance on of cession as a given in treaty making and Crown sovereignty as presumed has been foundational for all subsequent litigation that's taken up questions of what these treaty relationships entailed and the obligations they contained. And just something to keep in mind that I wanted to sketch out a bit more fulsomely, but have not been able to, is then the ways in which the courts focuses in on very specific articulations of self-governance under the kind of framing of Aboriginal rights by forcing Indigenous nations to have to, again, lay out very particular aspects instead of self-governance more broadly, as we see with both Delgamuukw and Pamajwin. So the courts have sought to address some of these quandaries that have arisen as a result of the divergent views of the treaty relationship through the development of canons of treaty interpretation, calling for treaties to be interpreted as they were understood by the signatories. So treaties are to be given large, liberal, and generous interpretation in favor of Indigenous peoples. Ambiguities in treaties are to be resolved in favor of Indigenous peoples. Treaties are to be interpreted in a flexible manner, and extrinsic evidence should be used to determine the meaning and intent of treaties. The courts in the United States have even applied and upheld what's known as the reserved rights doctrine, which notes that any Indigenous nation's rights not expressly ceded or extinguished remain intact. So while these canons, when they're adhered to, can be favorable for unearthing Indigenous interpretations of their treaties, they nonetheless compete with legal principles that enable the infringement of treaty rights when such an infringement is deemed justifiable. In addition, though calling for flexible interpretation, the canons still rely heavily on historical evidence to shed light on the spirit and intent of treaties. So this reliance on historical evidence has at times been favorable for Indigenous nations. Nonetheless, much of this work has paid little attention to how interpretations get carried into the present. This is partially due to the fact that the courts have primarily focused their attention on historical interpretations of treaty, notwithstanding their willingness to recognize that Indigenous people should be able to carry out treaty rights in modern forms. So this attention to interpreting and understanding the past, while important, has nonetheless constrained, I would argue, our understandings of treaties, putting us at risk for thinking narrowly about the relationships they entail. So this raises the question of how historical interpretations of treaties may be creating an incomplete picture of how we understand these binding agreements. And I think this happens in two forms that I'll talk about. The first is the court-driven agenda that shaped and contained how we understand treaties. So indeed, we recognize that much was left out of the written documents, and yet we continue to focus our attention on the interpretation of particular clauses. We spend a great deal of time focused on rights to hunt, fish, and gather, which indeed are important and worthy of this attention, but I cannot help but wonder if it's locked us into framing our treaty rights in language that is both comfortable and recognizable to the state. Courts are culturally subjective institutions, and judges are indeed influenced by their, at times, archaic notions about Indigenous peoples. So for example, judges are often able to recognize Indigenous rights to hunt and fish for subsistence, but they struggle in extending these rights to commercial activities, though this has happened in some cases. Similarly, judges in Canada struggle to envision treaty signatories as having retained or reserved their sovereignty in their treaty relationships with the Crown, while putting forward a vision for coexistence across a multinational terrain in which Indigenous nations and Canada, or the Crown, are bound by their obligations and treaty commitments. We look to Section 35 of the Canadian Constitution as an affirmation and recognition of treaty and Aboriginal rights that have constitutional standing, and it is indeed the case that these rights are constitutionally guaranteed, and there were many who fought for this protection. But in celebrating this affirmation and recognition, I continue to wonder whether we must also be aware of the dangers posed by the constitutional inclusion of Aboriginal and treaty rights. Has the attention to Section 35 enabled people to slip from understanding pre-existing treaty-protected rights as inherent rights that were merely recognized and affirmed by the Constitution, to instead understanding these rights as derived from the constitutional framework or contingent on a grant of authority from the state? So while legal scholars have, of course, been careful to position these rights as pre-existing, the attention to Section 35 has nonetheless locked these discussions in some ways within a state framework, instead of situating them as part of a dialogue about nation-to-nation relationships. Indeed, the Canadian courts often close off and contain discussions of self-government and fail to affirm and recognize Indigenous sovereignty. They've failed to consider even more narrow questions about treaty rights that focus, for example, on taxation, small business enterprises, and Indigenous economic efforts that fall outside of capitalist market-driven, extractive-oriented agendas. So if we're going to take Indigenous assertions of sovereignty and nationhood seriously, as well as the laws and political traditions that give shape and meaning to Indigenous nationhood, we must also ask what treaty rights exist beyond the scope of hunting and fishing. If Indigenous peoples were not ceding lands, but instead creating a shared territory that would enable peaceful and mutually beneficial coexistence of separate nations, how must our understanding of treaty rights expand to account for these interpretations? So this brings me to the second point for consideration. In focusing on the historical interpretations of treaties, we continue to put forward an agenda shaped by our belief that the answer lies in understanding the original spirit and intent of treaties. While Indigenous leaders invoke this language to call for more expansive engagement with the Indigenous philosophies and laws that undergird treaties, the courts have too often restricted this language of spirit and intent to questions of what Indigenous signatories understood about particular clauses within the treaties, or to the historical context of a particular treaty. And while these questions are important, I believe that this has also limited our understandings of treaty relationships. I instead argue that the answers lie in understanding the larger framework of Indigenous governance and legal traditions that actually gave meaning to the historical treaties themselves. So let's take, for example, Anishinaabe teachings about the earth and our relationships to creation. How might our understandings of Anishinaabe governance and legal principles regarding creation impact our interpretations of treaties? So in order to understand our treaties and the rights we reserved, it's imperative that we account for the pre-existing relationships and legal frameworks that informed and gave meaning to these treaties. In order to do so, we must pay attention to Anishinaabe governance and legal traditions that gave shape and meaning to our treaty relationships. So by looking to the broader philosophies and legal traditions that informed our treaty relationships with the Crown, we bring forth a new set of questions regarding treaty rights. If we take the ways in which Anishinaabe relationships with creation shape treaties into consideration, in thinking about the legal framework, for example, of a breach of a treaty relationship, then we must make space for Indigenous peoples to be able to hold the state accountable to the pre-existing relationships we have with creation. Better yet, we would need to make space for Indigenous peoples to teach the state how to properly engage in relationships with creation. So here I'm going to shift a bit, and it's going to feel jarring, so get ready. So I want to shift a bit to thinking then about this, how we think about relationships to land, to consider the dangers that persist in this construction of Aboriginal and treaty rights that effectively severs Indigenous political authority from our territories, to instead attach our rights to particular practices, our authority to particular practices. And here I'm thinking the right to hunt or fish. So here I'm interested in thinking about how a narrow construction by the courts of our relationships to land as usufructuary rights, framed largely through this language of culture or cultural right, is directly in opposition to legal principles that drove Indigenous engagement in treaty relationships in the first place. So put simply, the framing of treaty rights through the language of rights to hunt, fish, and gather effectively fails to account for the normative legal world that shaped and informed Indigenous treaty making and the principles and promises that arise from those relationships. And by here I mean it does not fully account for our own legal traditions that dictated how we carried out these practices of hunting, fishing, and gathering. So to get at some of these concerns, I want to focus on two dimensions around the kind of discourse of relationship, or what it might mean to move towards a more relational paradigm. And so in doing so, I just want to consider how discussions of knowledge and land more broadly elucidates the kind of dual potential for a return to a relational way of being can function as either an empowering or a restrictive kind of approach when invoked in various contexts. And so a lot of these thoughts grew out of conversations with Cree scholar Gina Starblanket, who was a Ph.D. student of mine, who's now an assistant professor at the University of Manitoba. So she took up some of the questions around gender and notions of modernity and technology, and I took up some of these questions around land and knowledge. Okay, so the first consideration when I think about knowledge, or the kind of first point I wanted to really think about in thinking about what does it mean to be in relationship, was about how do we attend to power. And in this case, I want to just focus that very big discussion of power on how we think about knowledge. So I ask how a shift towards a relational paradigm can aid us in being attentive to power and the asymmetrical relationships born out of power imbalance. So the shift towards a relational requires that we not just acknowledge these imbalances, but also actively work to mitigate the positions and privileges they produce. We must ensure that we don't reproduce the very logics that have too often ordered our relationships in violent and destructive ways. So while attention to power can provide insight into various dimensions of relationship, I focus my attention here on how power operates through knowledge production and its classification and codification. We must contend with how we are engaging with and producing knowledge. We have to ask ourselves what knowledge counts and in what ways. So we must move beyond merely a considerate citational politic, beyond which sources of knowledge we take up. We must intently focus on how we take these sources up. For example, why is it that we classify some works within the academy as theory and others as story? What is lost when we fail to understand theory as a set of stories, or when we fail to consider theories produced and contained within stories themselves? And story is not just theory. As Leanne Simpson reminds us within Anishinaabe thought, theory is generated and regenerated continually through embodied practice and within each family, community, and generation of people. Story is also a practice. It is rooted in relationality, in our relationships with one another and creation. So taking Indigenous knowledge seriously means not just taking up different answers, but instead, or at least in addition, requires raising a different set of questions. Indigenous knowledge is too often treated as an additive to Western knowledge, eclipsing its transformative powers. For example, many Indigenous scholars have highlighted the colonial entrapments of state-driven projects such as recognition that contain Indigenous knowledge within settler colonial logics that foreclose alternatives to these initiatives. Indigenous legal traditions are often taken up, again, in the US and Canadian courts only so far as they can provide insight into predetermined questions constrained within Western legal traditions. In these contexts, the scope and breadth to which Indigenous knowledge can shape conciliatory practices is already circumscribed and constrained. So we have to be attentive to how power structures and determines which narratives or modes of understanding our world and the webs of relationships and operation are given primacy. Furthermore, I think we must untangle how these narratives have ordered how we relate to one another and to creation. Too often, conventional Western knowledge is willing to turn to the relational only insofar as this attention to relationship doesn't threaten the stability of the state. For example, foreclosing more expansive conceptions of treaty relationships eclipses the concomitant questions these understandings produce in relationship to state claims to sovereignty, land title, and political authority over Indigenous lives. We need to be attentive to how asymmetrical power relations have enabled conventional Western knowledge to produce hierarchies of knowledge that too often mute modes of understanding the world as deeply relational and interconnected, as put forward by so many Indigenous thinkers. I think we see similar forms of containment operating, for example, in educational contexts with efforts towards indigenizing the academy. It's my little beef today, apparently. So this rarely involves the expansion of Indigenous programming that takes Indigenous knowledge production at its base or is directed and driven by the questions and concerns of Indigenous communities, both the grounded concerns of Indigenous nations and their citizens or the related intellectual inquiries coming out of the field of Indigenous studies. Instead, widespread attention and resources have been dedicated to the expansion of Indigenous responses to and critiques of the central tenets and concerns within the Western disciplines. Indigenous knowledge becomes contained within these disciplinary traditions that both drive the questions deemed important to their respective field and determines the metric for successful engagement and mobilization of knowledge. In fact, even within Indigenous studies, much of the celebrated and well-funded scholarship is focused on works that make critical interventions in long-standing Western disciplines, dismantling the theories of critical to a particular field. These works are often brilliantly theorizing Indigenous experiences with and responses to colonialism and warrant considerate engagement, so I don't discount that. And indeed, Indigenous studies scholarship recognizes we are not outside of colonialism, but actively engaging with and impacted by its structures and logics. And this is important work. But I think the question remains why Western academic fields will often only engage Indigenous knowledge when it's translated through the language of their discipline. Why does the onus continue to reside with Indigenous knowledge holders to translate Indigenous knowledge into cognizable frames? And I think we can see that as well when we think about the inclusion of Indigenous law within the Canadian courts. And even when Indigenous and non-Indigenous scholars do this work, Indigenous knowledge is most often given consideration or taken up by Western thinkers when there's either a vacancy or a bankruptcy in Western thought, replicating a power binary between Western and Indigenous knowledge. For example, when Western scientific knowledge fails to provide insights for how to live in a precarious world impacted by devastating natural events such as earthquakes and tsunamis, attention will be given to Indigenous knowledge systems, recognizing that Indigenous peoples have had to contend with these concerns since time immemorial. Yet, even when Western thinkers are willing to consider the stories that detail these historic events that are absent from the Western historical record, they often fail to give consideration to how Indigenous knowledge posits we are part of a web of relationships that give rise to these moments. Instead, Western divisions between humans and nature are reified even while considering the Indigenous stories that actively work against this categorization and binary by detailing the interconnectedness of creation. And here I'm specifically thinking of an article that was taking up Coast Salish knowledge around earthquakes, only to then continue to replicate all kinds of environmental degradation that was giving rise to earthquakes. So these tendencies minimize and contain the transformative potential of Indigenous knowledge, rendering it easier to incorporate and assimilate into the disciplines. We argue it's not enough then to make space for Indigenous knowledge. I think we must allow for this space to be reconfigured by Indigenous knowledge. So a shift towards a relational paradigm, I think, can also aid us in resisting this kind of continued containment of Indigenous knowledge. Noelani Goodyear, Native Hawaiian scholar, asserts, such containment can manifest in geographic forms as reservations or small school spaces, in political forms as legal recognition frameworks that seek to subsume sovereignty within the settler state's domestic laws, or in ideological forms as school curricula that allow a sprinkling of Indigenous history and culture only to maintain its marginality. So this logic of containment that she outlines functions to ensure that just enough Indigenous knowledge or culture is engaged and incorporated so long as the settler state and its colonial relations of power are not disturbed. So this logic of containment operates as an extension of the epistemological and physical violences endemic to colonialism. And we see this logic at work, for example, in land claims and title cases that utilize a temporal framework that contain Indigenous relationships and responsibilities to creation as historical claims to prior occupancy. As Ms. Shauna Goldman highlights, quote, a consequence of colonialism has meant a translation or too easy collapsing of land to property, a move that perpetuates a kind of logic of containment. So this valuation of land to jurisdictional legal value fails to account for the relationality of land as a storied site of human interactions. In the process of this power-knowledge dynamic, land then becomes devoid of its agency and meaning-making potential, and instead is treated becomes objectified as a quantifiable good we live on, rather than a living entity we live with and generate knowledge through. So attention then to kind of relational ways of being can enable us to see how colonialism is always in relationship. It is not some abstract logic that operates outside of people. It is structural, but it's also a process that is dynamic, interactive, and fluid. So attention to the power and logic at work in state narratives enables us to better identify the productive quality of settler colonialism. And here I mean productive as generative, what it's generating. As Patrick Wolf has noted and many others have taken up, settler colonialism is seen as inherently eliminatory. So while bringing much needed attention to the structural aspects of colonialism, as this analytic has served to do, it risks eliding both power relations and decolonial possibilities if too much focus is given to this kind of native settler binary. Furthermore, this analytic also risks becoming overdetermined if focus is given exclusively to the kind of eliminatory logic that he draws out to the exclusion of the ways in which settler colonialism produces something. So this productive nature of settler colonialism, I think, is rooted in relationality. Indeed, settler colonialism doesn't just try to eliminate, Native peoples and our rights to lands, but in its place seeks to actively produce something new. But in the process, settler states do so through relationships with Indigenous nations. Settler colonialism then is not so much eliminatory as it's both reductive and productive or generative. And so it risks becoming further entangled within these tenets of settler colonial logics when we fail to account for how the state and settler regimes regulate and circumscribe our relationships. So here I'm saying we can't put too much attention just on how the state reduces Indigenous political authority and rights without understanding what the state is producing in its place, which is often its own kind of narratives that legitimate its existence. So as Leanne Simpson reminds us, our sovereignty does not come from a document. Our sovereignty comes from an abundance of healthy, responsible, respectful relationships with all of our relations. So how we ensure we're contending with, mitigating, and resisting colonial power, how do we ensure we're contending with, mitigating, and resisting colonial power that seeks to obscure Indigenous knowledge systems that shape our relationships with one another and with creation? And here I think we have to be attentive to making space for then present and future generations to dream a new way forward for our people, to learn from and with the land, to learn through our knowledge systems that derive new meaning from the long-standing knowledge that has sustained our peoples from time immemorial, in order to properly contend with the shape-shifting forces of colonialism. So the second consideration I want to take up, and the final one I promise, is land. So specifically, I'm interested in exploring the ways that relationships to land gets taken up in the kind of field of Native studies or Indigenous studies. And I ask how our attempts to combat colonial framings of land risks kind of reifying these Western containments or eliding a kind of broader understanding of the range of relationships we have to place. So in our efforts to assert our political authority in the face of state assertions of title over our territories, we ask how I'm asking here how we've foreclosed alternative forms of resistance by centering our attention on articulations of land that reify statist notions of bounded space. I question how this attention to land, while important, has eclipsed our focus on relationships to other aspects of creation beyond the land, such as, for example, water and our waterways. So while we often use the language of land to connote all of creation, has this framing prefigured relationships with and across the land as preeminent to those relationships with and across, for example, the oceans, lakes, rivers, and lifeways that enables our very existence? And finally, how have our attempts to assert our political authority through a framing of nationhood become wedded to territorial boundaries and fixed political formations that close off our rich understandings of how we relate to one another? And I think of this a lot because of my work with Sakimay First Nation, and we've talked a lot with them. They've spoken with us a lot about, how it is that we become so wedded to this idea of who we are that's bound to our reserves without thinking about the broader relationships we have to the other Indigenous nations around us who we have long-standing relationships with. So in the process, do we then enable a kind of fulfillment of colonial efforts to restrict Indigenous kind of mobility and the building of larger political mobilizations by tethering indigeneity to land so tightly? So Indigenous scholar Vince Diaz reminds us to be attentive to this trap, noting the need to be cognizant of how we as Native peoples sometimes unwittingly perpetuate colonial definitions of land through ways that we invoke this kind of primordial connectedness to landedness, particularly in political programs of reclaiming stolen land bases. So he asserts that this romanticizing of pre-contact Indigenous life poses at least two risks for Indigenous nations. One, it obscures the hard work that produces Indigenous knowledge and enables the flourishing of relationships with humans and non-humans. And two, in the absence of this attention to the work involved in living out our own relationality, this makes space for settler replacement narratives that posit Indigenous relationships and knowledge as natural and innate, and as a consequence, positions Indigenous realities today then as inauthentic and contaminated by colonialism and the rise, and in doing so, then positions the rise of the settler state as inevitable and thus inculpable. So settler colonialism aims to separate land from the rest of creation in order to enable territorial expansion for the state. So the discourses of land that essentialize our relationships as fixed in some pre-contact context risk eliding the ways in which grammars of race, class, gender, sexuality, and sovereignty operate at the local, regional, and global levels to produce the settler state itself. One way we can combat this is through attentiveness to how place matters. So this requires operationalizing a critical positionality and reflexivity that's about understanding ourselves in relationship to the place we are. To understand how settler colonialism has ordered and reordered our relationships to place, that requires us to take greater care in understanding our engagement with place as a series of meaning-making practices. So we must bring forward our own rich stories about how we relate to creation, which means we must expand our focus to include both the other living beings that have shaped and regulated our relationships to land, as well as how our relationships with and across land are generated through our movements across these territories. So I think we need to actively work against colonial narratives that seek to divorce us from these relationships by configuring land as bounded territories in which only our primordial practices can permeate, so long as they're understood as temporally or spatially fixed, and discursively then remade as cultural rights to ensure kind of minimal material impacts for the state. So we can resist this move by, I think, ensuring we're creating space for relationships that are generative, that cultivate not just the continued transmission of Indigenous knowledge, but also ensure the production of Indigenous knowledge. So in detailing land as pedagogy, Anishinaabe scholar Leanne Simpson relies on the story of Puezance, a young girl who learns both from the land and in interaction with the land, bringing the knowledge of how to make maple syrup to her people. It's not just Puezance's ability to learn with and from the land that generates this knowledge. It is further cultivated through her loving relationships with her family, her mother and aunties who trust in her knowledge and support her in working through her understanding of the land, and in this context, the maple trees, when she's unable to reproduce the running sap at first attempt. Simpson asserts in this way, quote, "The land, or a kih, is both context and process. It is through the activation of our relationships with the living entities that constitutes this expansive space, the land, animals, spirits, and humans, that knowledge is produced and transmitted. The generative quality of our movement across creation necessitates attention to and accountability for our positionality. This requires that we be attentive to and ground our analysis of relationships in the places we are, and where we are is always changing." So the containment of Indigenous lands, I feel like that's right though. The containment of Indigenous lands to reserves or even the more expansive Aboriginal territory can risk us assuming that our movements through our own territories are not also always regulated and conditioned by relationships and responsibilities. In fact, it is in our engagement with place and with others in these places that gave rise to our political practices in the first place. So a greater understanding of how our own mobility through our territories is generative can help enable us to see how discourses that fix us, like in a specific geography or time, then reduce the ways we think about our expansive knowledge. So for example, I think the story of Puezance nicely demonstrates the danger of failing to see what Leanne Simpson calls land as pedagogy. So if we fail to account for how our movements across and engagement with place give rise to knowledge and practices, then we see the practice of making maple sugar as the kind of what it means to be Anishinaabe, instead of, and I love maple sugar, so I'm down for that. But I think importantly, what she's trying to highlight is that what we need to see is what is at the core of what it is to be Anishinaabe is the practice of engaging creation and nurturing new knowledge production as essential. So surely this is a story that's about how we came to receive the gift of maple syrup. But more importantly, this story serves as a guide for how we can bring forward new gifts to aid us in this ever-changing world. So the greatest tool available for Indigenous peoples is not in the revitalization of our traditional practices, though this is important, but instead can be found in the actual processes that gave rise to these traditions in the first place. So it's in our mobility, our movements across our lands and waters that activate our relationships and responsibilities. And the flattening then of Indigenous space to territorial delineation of bounded spaces, marking ours and theirs, not only reifies settler claims to unceded lands, but also presumes Indigenous spaces are unregulated, failing to account for the ordering of relationships that produce the balanced interactions with creation that have become posited as natural and innate by the state. So attention to how we relate to one another can combat these kind of colonial containments of Indigenous authority. So as Goldman states, Indigenous peoples came to occupy certain physical and imaginative spaces in the colonial mindset that existed within strict gender and racial hierarchies. Indigenous subjects became and become subsumed in these differences. So the abstraction of this difference has served as a tool of settler creation myths to legitimate the state. She warns, quote, "In our pursuit to differentiate ourselves from settler colonists, we have territorialized land and body. This territorialization has resulted us placing focus in Western conceptions of nationhood and citizenship that center on rights of and responsibilities to the nation, then to our relations to one another and creation." So Indigenous assertions of our nationhood have been important mechanisms to protect and carry out our relations to creation and to one another. But in the process, I wonder if this form of resistance has distracted us from exploring how we understand ourselves in relation to others. When we express the place we come from, we often name our reserves or treaty territories, and these are important linkages we're laying out. But I wonder how these assertions center our focus on our Indigenous polities to the expense of our attention to the territory and relations we come from. Of course, we often acknowledge this as well, delineating our familial or geographic lineage. But I nonetheless wonder how we're complicit in the perpetuation of colonial containments of Indigenous political formation by centering our own attention on bounded spaces produced out of treaty relationships with the state. And Rob Innes asks these questions in his study of the Cowessess First Nation. And these are questions, again, that I said have increasingly come to my attention in working with Sakimay and them thinking about their relationship and their longer history as part of the Iron Alliance. So for the Anishinaabe, we speak of ourselves as the last of creation. And this is not just some inversion of the hierarchy of creation, but with ourselves as the lowest and thus the least valuable. Instead, Anishinaabe attention to our order of placement on the earth reminds us of our obligations to those who came before us, who already governed the territories we came to inhabit. As our stories and the practices they give rise to denote, the animals stood up for us and brought us into an already regulated and governed territory. Our clan governance then is an extension of these relationships, reminding us that whether we're moving through our lands or visiting the lands of others, we must always account for the web of relationships that order these spaces. We offer our tobacco to the water beings before we enter our canoes and boats. We petition the plants and animals in recognition of their agency and our relationships with these beings. We engage in political exchange and the expansion of kin relationships when moving into the territories of others. So we're always in relationship and are always aiming at nurturing and expanding these relationships. So I just want to contend that attention to our kind of mobility then enables us to unearth the productive or generative nature of our relationships with creation and with others in our movements across creation. So in conclusion, I think it's important to remain mindful of the ways in which the kind of discourse, both in the ways in which kind of state discourses frame us in very particular ways, but then also in our own resistance to those discourses, we might risk reifying and reproducing some of those same constraints. and that we should be mindful then in our discourses of relationship and resurgence to make sure that we're not masking or legitimating oppressive practices. And so here I think we can draw our attention to the ways in which we might violate our own responsibilities within relationships through neglect or oversight, or through explicitly destructive or abusive forms of interaction, that we have to always be attentive to that and thinking about that. So for instance, many people recognize that they inhabit a treaty relationship, but they continue to tacitly or explicitly contribute to the violation of the commitments that they entail. Or they claim a deep connection to a particular geography with little awareness of the ways in which their actions might contribute to harming these same spaces. So in other words, acknowledging a relationship between self and other doesn't necessarily translate to the full range of actions that are required to inhabit relationships properly. Furthermore, the very process of drawing out our responsibilities within relationship is itself subjective and highly politicized, with the potential to implicate others in ways that they might find disempowering. So while being committed to resurgence and the regeneration of relational ways of being may seem at times relatively straightforward, enacting these commitments on the ground in our day-to-day lives give rise to a series of complex questions and contradictions that we should always remain attentive to. So I'm going to stop there.
Thank you so much. We have about 15 minutes left, so if anyone wants to ask questions, I see one hand, and just for the benefit of the video, if you could repeat the question,
okay,
that would be great. Carrie, and then Douglas.
I want to talk a little bit about the phenomenon of treaty infringement from the framework that I think you are inviting us to adopt. So what I'm hearing you say is that we ought to understand the treaty relationship between the settlers and, say, the Anishinaabe as one in which the Anishinaabe are welcoming the settler presence into the pre-existing relationship the Anishinaabe have with creation.
Right.
So I'm guessing that if particular Anishinaabe conduct themselves in a manner inconsistent with that pre-existing relationship, the Anishinaabe know how to deal with that. So my question is, if you have a dumb, inattentive settler state with which you have a treaty relationship, misbehaving in a way that compromises the relationship with the rest of creation, assuming that Anishinaabe law is the paradigm, how would Anishinaabe law, if it were up to the Anishinaabe to enforce the treaty relationship, so to speak, how would Anishinaabe law deal with settlers that are acting inappropriate vis-a-vis the Anishinaabe understanding of the treaty relationship?
Yeah, so the question was about how Anishinaabe law kind of responds to treaty violations, specifically the ways in which Anishinaabe law might respond to settlers who are violating particular aspects of the treaty. And so here I would say two things, or I guess the answer I'll give to that is an example. The example I'm going to give is actually of an Anishinaabe who was violating one of the kind of core principles that would undergird the treaty relationship. So in Wisconsin, because the tribes have their own tribal courts and a number of tribal resolutions and regulations that lay out how people are hunting, and they're regulating their own citizens. They have a specific code that ensures that the treaty with the Hoof Nation or with the deer is kept intact by promoting that Anishinaabe continue to, again, put out their tobacco and petition the deer, but then also act in accordance with the various principles of that treaty with the Deer Nation by ensuring that we're respecting their bodies, using their bodies properly, et cetera. So they've actually produced a a code that fines hunters if they are found violating or having wasted the body of the deer. And so in one case, a young man had shot a deer and had the deer hanging and had to run back to Minneapolis a few hours from the reserve and had asked a friend to kind of take care of the deer. That friend failed to do so. A game warden came and found the deer rotting and fined the hunter. And then the hunter made the case, and this is where law is quite layered, right, for Anishinaabeg, and I think would apply to how settlers get brought into this, as he made the case to the judge, the tribal judge, that his violation of law was a violation of sacred law, and that was between him and the creator, and he had put out his tobacco and made it right. And the judge, being well versed in Anishinaabe tradition, was like, that's a good start. And then proceeded to lay out the various processes he would have to go through to actually remedy the kind of harm that he had caused to the deer. He agreed to do that instead of paying the state fine, and then failed to actually do it for a number of years. And the kind of like story or urban legend, if you will, across the community is that for years he was unable to have any success hunting, and then finally went back to the judge and was like, okay, what did you say I should do? And then carried out those practices and then found success. So I say that to say that as Anishinaabe, there's like much of our laws are driven towards helping ensure we're not violating those laws that we actually aren't the granting authority, right? So those deer will regulate themselves and might ensure you have no success in hunting. So our law is about ensuring that we keep our relationships healthy with creation, and I think that the concern is that the continued violation that settlers are making towards land may be felt in only small scale terms now, though I would say these are pretty radical feelings that we're having over what's happening, right? Like we can, if we're attentive to what's really happening around us, that's pretty large scale. Anishinaabe law, I think, is really driven to ensure we survive. And I think the real risk right now of like the continued violation of those treaty commitments and the laws that give meaning to them is that we're actually risking like our ability to remain in a sustainable relationship with creation.
So just to clarify, are you saying the natural world will enforce its own requirements, or are you saying something in addition to that?
I'm saying, so I think that Anishinaabe law will enforce its own, or like we will enforce things, but like it's just not a very coercive, like people have to be willing to do that work. I think that's been one of the struggles, is we're not a very coercive, like coercion is not a value that's like revered, right?
You're probably nicer people than the settlers are, which accounts for the different legal traditions.
Well, I mean, John Barros is for sure, right? I might not be the nicest. I'm pretty crabby most of the time. But you know, I think that that Anishinaabe law will promote a particular way of being in the world to ensure that those kind of violations won't happen, and people will encourage people towards the remedy when a violation occurs. And do as much as they can to promote that. And that happens through telling stories that's supposed to help the listener like come to these things more and more on their own, or take them out to these places that have been impacted, and help them to develop those meaningful relationships to place. And I actually think that can be like really productive for settlers if they were willing to really put in the work of what it is to inhabit a treaty relationship, is that I think they would find like really deep, meaningful ways of understanding how to live in the world. And that's my reason for focusing also on that story about maple sugar, is that like it's not just about like how we carry out traditional practices, it's not just about producing, like continuing to produce maple sugar, though we should do that. But it's like ensuring that the other thing we continue to pass on, I think both for ourselves and to bring settlers into that framework, is like to ensure that the process for how we develop knowledge in our engagement with creation persists, right? So we have to make sure like we're teaching young people how to dream, right? Like, and how to bring new dreams forward, and like how to like be in relationship with land that will actually generate the knowledge that might help us remedy some of the massive damage that's occurred. Because I think we do see that with the floods, with the, climate change, everything else, right? That we have a lot of the remedies for that, but if we don't teach young people how to like engage with the land in ways that produce new forms of knowledge, I don't know that we have enough that's going to help us out of some of the new forms of destruction that are taking place. So, yeah.
So Karen, first I want to say, if you finally do come to my class next week, we will be looking at how the 5 nations dealt with treaty violations with the British, at least in the historical context. So my question, with respect to the treaty interpretation and Aboriginal rights and title that we talked about earlier on, do you think that the Canadian courts can ever get it right? And if so, why?
Like, why would they?
No, why would you think that?
I was like, did I just say my brother's a lawyer? No. No, I mean, obviously, I think Indigenous engagement with the courts has often not been because there's like a strong hope that they're going to get it right, but because we're like outliving our laws and we keep getting arrested for doing so, right? And you're not just going to like leave your uncle or your grandma or your auntie in jail. You're going to try to find ways to get them out. Or, but I think that, so I think there are more productive spaces for these conversations to happen than in the courtroom. But I also think that we have to be like very attentive to and critical of how legal decisions are being produced because they do have so much power.
So, but I just think that in the absence of a belief that the courts are actually going to get it right in the future, isn't it time that we started to like talk about legislation? Like, couldn't Parliament introduce legislation in conjunction with First Nations around the duty to consult that might incorporate UNDRIP or around what is an Aboriginal right? Like, we've let Parliament just completely abdicate their responsibilities since 1982, and mostly all we do now is complain that the courts got it wrong. And so,
yeah, well, I mean, this is where I think like, I mean, like we should look to the legislation is like the, I mean, this is where I'm getting super poli-sci, right? Like, that's like making law, right? The court's job is to interpret law, and that's where they're like, that's the problem is that right now the courts are making law in places like, or at least I think these like discursive fictions that have material implications when we already have those laws because those treaties are already in place. So I guess, like, I don't think the production of legislation is a bad idea. Obviously, I come out of the States. I'm trained in so I mean, obviously, like, the last 4 decades have been like a lot of legislation, but that alone is not saving Indigenous nations south of the border from also having a lot of their political authority stripped, and that legislation often finds itself then being interpreted by the courts, right? We thought Section 35 would do the same thing in terms of like protecting Aboriginal and treaty rights. And the problem isn't with the Constitution, well, it might be, but the problem doesn't necessarily have to be because they're constitutionally entrenched, right? Like, it would make sense that Canada would recognize in its constitution that it has a relationship with Indigenous nations. The problem has been in the ways in which the courts have chosen to interpret the kind of scope and meaning and application of Section 35. So I think we should always be taking diverse approaches because I think it's a slow and steady fight, and that's where, like half of the things I have said in here, if not more, are also aimed at us to think about like, what are the things we're internalizing? What are the ways in which we too risk not like hearing the teachings of our elders properly when we like become really wedded to resistant tactics against the state that like a generation later means we've forgotten like what we were actually reserving in treaties, right? Because it wasn't just the rights to hunt and fish and gather, and like how much of our own understandings of treaties are being lost by not also having broader discussions beyond like this really state-focused approach. So I think diversity in terms of our approaches is crucial. Yeah.
So we've got 2 minutes left and one more comment.
Yeah, I just want to say that it's interesting to hear these words. King Gego Inakon to talk about what's happening these days, like, you know. But I didn't hear the word extinguishment. The word I got here a little late, but the extinguishment is one of the policies in terms of the federal government, the relationship with the treaties. And treaties, for all their worth, but actually legal instruments of stealing indigenous land. That still holds today in terms of treaty. When you look at the treaties, how many treaties were honored? How many treaties were there's still a lot of violations, land claims, and I've worked in treaty research for years and years, and anything that starts today will take years and years and years, because the imbalance of we may have one research, we may have one lawyer, but there's a mountain of the other side of the table, which is the government, and with very deep pockets. Mountain Ojibwe Idam come going Gabamanic Kiiwetinepinesiik Stark. This is how the land is disappearing. You'd be surprised to, you may or may not know that out of 100% that we occupy, lived on, whatever one wants to call it, it's only 0.02%. And the rest of the 99.8% is ours. Someone asked me one time, what did you call your land before the settlers came? You know the answer to that? Ours. It's very, very easy, and we welcome when your ancestors came to the shores, we said, come and eat of our abundance. There's lots. Nobody said anything about putting up picket fences. Nobody said anything about, we're going to put you in little pocket-sized reserves, and in terms of, and then we're going to promise you these through treaties. I know the treaties, to me, are. I'm not a great fan of treaties. It's simply because they them as instruments of land. And you look at the, for example, in law school, I asked one of the professors up in law school, I said, can you honestly say, I asked him where he lived. I said, well, I live in Toronto. Can you honestly say that where you live, based on statute after statute after statute after statute, can you say that land is yours? Here's a learned scholar who said, no. So in essence, when you look at the reality of the treaties, I forget which elder said it back in the Constitution conferences, but we still own Canada lock, stock, and barrel. And this elder, Junior Constitutional Conferences, challenged all the premiers. Can any one of you challenge that? None of them spoke up. It's not to say that we love it back, but we're not saying that we're going to revolutionize, we're going to cut a revolution or anything like that. We just want to understand where we stand. That's a thing that within the legal profession, within the it has to be understood. It has to be understood. And the land, when you look at the word Canada, I'm very fluent in my language. And when they asked us, what did you call it? What do you call your land? Kena, which means the land is all my heart. Kena, which is Canada. When you break down that word, Canada, and that's when we talk about the earth. The earth is our mother. The earth is what nourishes us. The earth is what we today we borrow from our children, or from our children, those that come behind. our children, their children, their children's children. But I think when you look at the, what today, when you look at the treaties, look at the, you know, the various, I guess, legal, whatever, that's still, it's still, you know, word conquest by law. And it's a little bit American side, but that's conquest by law. But the idea that, you know, yes, we're sharing our land, but what about the resources? Why are we still in third world countries? In Canada, it's supposed to be one of the most prosperous countries in the world, and yet we still have third world country conditions among the First Nations. This thing that, you know, law students or whatever here, I'm not sure there's a law student here, but it's the thing that the natural law that we've had for thousands of years, that's what used to the gentleman was saying that, what, you know, what dictates that we continue to maintain our livelihood, our mother of the earth, something that's very, you know, sacred to us. And there's some of the things that I would like to add, but however, time is, I think, and then I'll be the turtle. I've been there, yeah. And Chimiwech, my name is Ernie Sandy, and I graduated University of Western Ontario back in 1987, class of 87. Canadian social history, political science, and journalism, and pre-law. So, I'm in. Right?
Thank you.
Yeah, and also I sit on the Elders Council here at the university. And, anyways, Chimiwech Gabsinduek, you know, and I got a lot more to say. I mean, I got tons and tons to say.
I was about to say, here, just come sit here.
Well, everybody's got summers to go. I know it's Friday, and I'm really grateful for all of you coming out on a busy day. And I'm very, very grateful to Heidi for sharing her insight with us. And I know that there are going to be a lot of discussions following up. And we did take a video of the event, so folks will be able to watch it again and share it with friends, because I know that there are lots of people who wanted to be here who couldn't. So please help me thank Heidi.